Thank you, Chairperson. Sitting with me at council table is a CLF intern law student, Lauren Moore. As the EFSB and opposing counsel will probably recall, she was here last time that we had to clear the room for handling confidential information, and she is a signer of the non-disclosure agreement in this case. Good afternoon, Mr. Niland, sir.
Good afternoon, Mr. Elmer.
Have you discussed the subject of your testimony with any person since you were last here?
No.
Let's start with Invenergy Exhibit 146A, the redacted non-confidential version. Let's go to the first page of the document. I will that's not what I thought it would be.
And could you just identify the document?
Yes, I'm sorry. We're looking for the January 12, 2018 Invenergy response to CLF's data request 14-5. This was the original one, not the supplemental one.
It's there. It's PDF page 8, Craig.
Just have time to go to the next page, perhaps.
Okay. So I think Ms. Beretta said page 8.
Yeah, PDF page 8.
There it is. And I will just indicate for the record, Chairperson, that I've had a correspondence with Invenergy's counsel, Mr. Laser, and he has informed me that although this data response was signed by Chris Zadlow of Invenergy, that Mr. Niland is the correct witness to put questions to about this document.
I believe what I said is he's an appropriate witness to put questions to, but yes, that's correct.
Mr. Niland, I would like to direct you to the first sentence of subpart B in Invenergy's response, which says, Invenergy is an experienced developer and builder of energy infrastructure. Did I read that correctly?
Yes.
Was that statement true on January 12th, 2018 when Invenergy made the statement?
Yes.
Is it true today?
Yes.
Was it true on November 9th, 2018?
Yes.
Okay. Let's look next at Invenergy Exhibit 1B. And I want to project the 3-page cover letter that is part of a longer exhibit that I believe appears at the front of the exhibit. And I will identify it for the record. Am I correct, Mr. Niland, that this is a November 9th, 2016 letter to the EFSB from you?
2015?
I apologize, 2015.
I believe I signed it after.
So,
yeah.
if the projectionist could take us to page 3.
Yes.
And so you signed this letter in your capacity as an employee of Invenergy, is that correct?
Yes.
And on page 1, the letter is written on Invenergy letterhead.
Yes.
Let's look at the bottom of page 2. And if we could enlarge the chart at the bottom, and yes, thank you. On page 2, under a section entitled Permits, you list the permits that Invenergy needs in order for this project to go ahead?
Yes.
In fact, you titled the table here, quote, "List of required project licenses and permits," unquote. Is that right?
Yes.
You didn't call this list strictly optional project licenses and permits, did you?
No.
When you sent this letter to the EFSB on November 9th, 2015, did you believe that it was important for you to be truthful to the EFSB?
Yes.
Why?
I wanted to be accurate in terms of they had a request to us to list the permits that we would be seeking.
And you, in fact, were truthful in this letter to the EFSB in 2015, weren't you?
To the best of our ability and the best of the input that I got from our subcontractors, yes.
And by coincidence, this November 9th, 2015 letter was written exactly 3 years to the day before Invenergy's November 9th, 2018 FERC filing. Is that right?
Yes.
And the first item in the chart refers to the EFSB permit to construct a major energy facility, and that's this docket here. Is that right?
Yes.
And the fifth item down is the Clean Air Act major source permit that has been discussed here in earlier proceedings. Is that correct?
Yes.
And you'll confirm that it is a fact that in order to build this power plant, Invenergy needs a major source air permit under the Clean Air Act. Is that right?
Yes.
And that Clean Air Act permit would be issued by the Rhode Island Department of Environmental Management. Is that correct?
Yes.
Will you agree, subject to check on the date, that Invenergy submitted its major source permit application to DEM on or about June 26, 2015?
Subject to check, but that sounds right.
Would June 2015 sound right?
Yep.
And Invenergy, being an experienced developer of fossil fuel power plants, knows very well that every fossil fuel power plant needs a major source air permit under the Clean Air Act. Is that right?
Yes.
For example, Invenergy's Lackawanna, Pennsylvania gas-fired power plant, which Invenergy recently completed, had to apply for a major source air permit under the Clean Air Act.
To the PA, Department of Environmental Protection, yes.
Yes. And Invenergy's Lackawanna gas-fired power plant obtained a major source air permit under the Clean Air Act. Is that right?
Yes.
So on November 9th, 2018, Invenergy had actual knowledge of the fact that it required a major source air permit from DEM under the Clean Air Act. Is that right?
Yes.
Isn't it a fact that on November 9th, 2018, DEM had not yet issued a major source air permit for this proposed power plant?
2018?
2018.
That's correct.
Just so we're clear, by November 9th, 2018, Invenergy did not have the major source air permit from DEM.
That's correct.
And isn't it a fact that on November 9th, 2018, DEM had not yet issued a draft air permit for this power plant?
That is correct.
And isn't it a fact that today, DEM has not issued a draft air permit under the Clean Air Act?
Not a draft, no.
Another line item in this letter. Three lines up from the bottom is a wetlands permit from ACOE. Is that right?
Yes.
And you understand that ACOE is an acronym for the Army Corps of Engineers. Is that right?
Yes.
November 9th, 2018, had Invenergy filed its permit application yet with the Army Corps?
Yes.
So on November 9th, 2018, Invenergy had actual knowledge that it required a permit from the Army Corps of Engineers because Invenergy had already filed the application for that permit. Is that right?
Yes.
On November 9th, 2018, had Invenergy obtained the required permit yet from the Army Corps of Engineers?
No.
Another line item in this letter, one line up from the bottom, is a, quote, preliminary determination for waiver of asset requirement, unquote, from CRMC. Do you see that?
Yes.
And CRMC is the Rhode Island Coastal Resources Management Council. Is that right?
Yes.
Isn't it a fact that on November 9th, 2018, Invenergy had not yet obtained the required waiver from CRMC?
That is correct.
And isn't it a fact that as of today, several months after November 9th, 2018, Invenergy still has not received the waiver from CRMC?
That's correct.
Am I correct that in order to build this power plant, Invenergy would need a wetlands alteration permit?
Yes.
That wetlands alteration permit would be issued by the Rhode Island Department of Environmental Management?
That's my understanding.
Isn't it a fact that Invenergy submitted a wetlands alteration permit application to DEM on or about April 3rd, 2017?
Yes.
And the reason that Invenergy submitted a wetlands alteration permit application to DEM was that Invenergy knew that without such a permit, its proposed plant could not and would not be built. Is that correct?
It was a permit required to construct the facility and the electrical interconnect.
Isn't it a fact that on November 9th, 2018, Invenergy had actual knowledge of the fact that it required a wetlands alteration permit from DEM?
Yes.
And it's a fact that on November 9th, 2018, DEM had not yet issued a wetlands alteration permit to Invenergy. Is that right?
That is correct.
And on that same date, November 9th, 2018, no draft wetlands permit had been issued to Invenergy?
That is correct.
Is it a fact, Mr. Niland, that on or about February 22nd, 2017, Invenergy made a filing with the EFSB in which Invenergy, along with National Grid, applied for a license to construct an interconnection transmission line for this proposed power plant?
Subject to check on the date, but yes, that sounds about right.
Chairperson, I'd like to provide the witness and the members of the board and council with a copy of the filing that opened that docket. I realize that it's a separate docket and I have very limited questions about that.
That's fine.
although CLF is not going to move admission of this as full, we can mark it for identification with the next consecutive number for CLF.
It'll be CLF 26 for identification.
So we'll refer to this as CLF Exhibit 26 for identification. Okay? 27. Mr. Niland, I'm not going to ask you detailed questions about the document. I realize this is a separate docket, but you do recognize this as the application that was filed by National Grid and Invenergy with regard to the interconnection line for this power plant. Is that correct?
Yes.
And although it's partially obscured, you see the EFSB confirmation stamp in the upper right-hand corner that this was filed on or about February 22nd.
Yes.
And looking at the back of this document, page 8, let's look at page 8. I'm sorry, page 9. The document is signed by Invenergy's attorney, Alan Shore, is that right?
Yes.
It's signed by Invenergy's attorney, Richard Beretta, is that right?
I see
On page 9.
Alan Shore, and the other signature on page 9 is Brian Schuler from Invenergy.
Now, under Mr. Shore's name, you see Richard
Oh,
R.
I see
Beretta.
his name listed, yeah. He didn't sign it, though. I'm not sure.
But his name appears on it.
Yes, exactly.
And Nicole Verdi's name appears on it as well.
Yes.
And in fact, in response to Invenergy's February 22nd, 2017 application to build an interconnection transmission line for this power plant, the EFSB opened docket 2017-01. Is that right?
Yes, I believe that is the docket number.
And Invenergy is a full party in that docket, isn't it?
Yes.
And Invenergy is represented in that docket by Messrs. Shore and Beretta and Ms. Verdi, is that right?
I think so, yes.
Isn't it a fact that on November 9th, 2018, the final hearing in EFSB docket 2017-01 had not yet commenced?
Yes, that's correct.
Isn't it a fact that on November 9th, 2018, the final hearing in EFSB docket 2017-01 had not yet concluded?
Yes.
Is it true that on November 9th, 2018, the EFSB had not yet made a decision in docket 2017-01?
Made a decision?
Made a decision. Whether to approve the
final
application.
decision?
Final
Yeah,
decision.
no, that's correct.
And isn't it a fact that on November 9th, 2018, the EFSB had not yet issued its final order in docket 2017-01?
That is correct.
And isn't it a fact that by law, the EFSB cannot and will not issue a construction permit for Invenergy's proposed interconnection transmission line between this power plant and the grid until the final hearing in docket 2017-01 is both commenced and completed?
Objection calls for legal conclusion beyond the scope of this witness's testimony.
I'm sorry, what's your objection?
Calls for legal conclusion, he said, by law, and it calls for legal conclusion that this witness has been qualified as an expert in this, at least in the legal requirements, and number two, it's beyond the scope of this witness's testimony.
I'll allow it.
Do you have the question in mind, Mr. Niland?
Yeah, whether by law the board is allowed to issue.
The question is, the EFSB cannot and will not issue a construction permit for Invenergy's proposed interconnection transmission line until the final hearing in docket 2017-01 is both commenced and completed?
I believe so.
You're the project manager for this plant.
Yeah.
And Invenergy is a very experienced developer of fossil fuel power plants.
Yes, I would say so.
Do you have the slightest doubt that the EFSB cannot and will not issue a construction permit for the transmission line until after the docket in that case is completed?
Oh,
I believe the witness has already answered the question.
I said yes, I believe so. Yes.
I got
Sorry, I
it.
have an objection.
Oh, sorry.
Asked and answered.
Wasn't it answered?
No, it wasn't answered. When I first asked the question, I got an equivocal answer. Well, I think so. And this question is, does he have any doubt about that?
Well, first of all, Mr. Elmer just misrepresented what the witness testified, but the record will show what the record will show. But nevertheless, the witness did answer the question the first time.
Could you read it back, please?
Do you have sliced out that the EFSB cannot and will not issue a construction permit for the transmission line until after the docket in that case is completed? Sorry. The question is, the EFSB cannot and will not issue a construction permit for Invenergy's proposed interconnection transmission line until the final hearing in docket 2017-01 is both commenced and completed. The answer is, I believe so. Question, you're the project manager of this plant. Answer, yes. Question, and Invenergy is a very experienced developer of fossil fuel power plant. Answer, I would say so. Question, do you have a slightest doubt that the EFSB cannot and will not issue a construction permit for the transmission line until the docket in that case is completed? There was an objection, and the witness said, I believe so.
Isn't I believe so a response to the question?
Okay. Isn't it a fact that if the EFSB denies a permit for the interconnection transmission line, this power plant cannot be built because Invenergy will be unable to sell the electricity that the plant produces?
I would agree with that, yes.
Mr. Niland, I have a hypothetical question for you.
I'll wait for the finish.
If a hypothetical person said on November 9th, 2018, that this docket for a building permit for this plant was the only gating item for the plant. Would that statement be true?
Objection. Number one, it's an improper hypothetical. This person has not been tendered as an expert with respect to whatever it is Mr. Elmer's getting to. Number two, with respect to, and you may recall, this is where we ended last week. What Mr. Elmer is referring to is a statement from Invenergy's November 9, 2018 filing with the Federal Energy Regulatory Commission. So apart from the fact that this calls for an opinion from a lay witness, and that's improper under Rules 602 and 701 of the Rhode Island Rules of Evidence. Number two, I'll object also on the ground of lack of foundation, because Mr. Elmer has not established, number one, that this witness had any role in the drafting of that document, or number two, that he knows what the author meant by the phrase, the only gating item for the project. And I will note parenthetically that nowhere in that document does the author of this document say that it's the only permit required. The phrase that Mr. Elmer keeps hammering at is the only gating item for the project. He hasn't established that this witness knows what that means, and he's asking him to speculate about what it might mean.
Do you know what that means, Mr. Niland?
No, not without seeing a full context. I'm not sure.
Chairperson, we're discussing here a document which is a full exhibit in this case. It was admitted full without objection. And we're talking to the project manager of a billion-dollar plant. I'm happy to show him the full document. I'm happy to show him the context in which it appears. But the question, if you have the stenographer read it back, is a proper one. The question does not call for Mr. Niland to speculate about what gating means. It doesn't require him to be familiar with the document that he says he's not familiar with, despite being the project manager of the project. The matter will, of course, be briefed by the parties after the case, and I think everybody would benefit from having Mr. Niland's answers to these fairly straightforward questions. Credibility.
I'm going to allow him to answer.
Do you have the question firmly in mind? Because we can have the stenographer read it back.
Yeah, the question is what was meant by the gating item?
No, that is not the question. The question is, if a hypothetical person stated on November 9th, 2018, that the EFSB permit in this docket was the only gating item for Invenergy to build a power plant, would that statement be true?
It could be, depending upon the context under which the rest of that letter is speaking to.
It wasn't a letter, it was a filing signed by Invenergy's lawyers, made with the Federal Energy Regulatory Commission. If the board thinks it would be helpful, I would be glad to show Mr. Niland. Mr. Niland says it depends on the context, and he has a good point, and I'd like to show him the context if I may.
Okay.
Could you remind me what exhibit numbers those are?
Yes. Oh. I can't. Ms. Lucarelli, can you answer Director Coyne's question? This is a full CLF exhibit. I don't have the number from
I
it.
believe it's CLF 20.
It's CLF exhibit 20.
And this is Exhibit 20, CLF Exhibit 20, or is it an Invenergy?
It's a CLF exhibit. Ms. Lucarelli is checking it out.
Could I ask what page number we're talking about? 4. 4, thank you.
Third line.
I have it, thank you.
I'll wait for Ms. Lucarelli and Ms. Verdi. Yeah. So for the record, we're looking at, yeah, I gave him a copy, but you can give him that one. So we're looking at CLF Exhibit 21. This is a full exhibit, and it's entitled Motion for Leave to Answer and Answer of Clear River Energy, LLC, and Invenergy Energy Management, LLC. And Mr. Niland, I'm going to direct you first to the top of page 4, the first few sentences at the top of page 4, but I want to give you as much time as you need to look through this document, familiarize yourself with it until you're comfortable.
If I may, Chairperson, could I have a standing objection to any questions of this witness with respect to this document, since no foundation has been established?
Yes.
Okay.
Can we go on, Mr. Niland?
Yes.
Okay. Please read into the record slowly for the stenographer the first 2 sentences at the top of page 4.
While the EFSB permitting proceedings were delayed, comma, the final stage, dash, the formal hearing, dash, was imminent when the termination filing was submitted, period. Given that the EFSB permit, dash, the only gating item for the project, dash, still can be obtained by early next year, comma, this is clearly not the egregious case that prevents Clear River from maintaining its CSO, period.
I'd like to turn to page 10 of the document. That statement on page 4 was so important to Invenergy that it essentially repeated the statement on page 10. Is that correct?
I'd have to take a minute to read this.
Let me help you. Please read into the record slowly for the stenographer the first 2 sentences on the top of page 10.
While the EFSB proceeding has faced an extraordinary number of delays, comma, final hearings are scheduled to resume at the end of November, with a permit decision expected promptly thereafter, period. While the EFSB proceeding was delayed pending commission action, comma, Clear River is prepared to resume the hearing and work toward obtaining a permit early next year. Dash, the only gating item for the project's construction, period.
On November 9th, 2018, the date this document was filed, Invenergy needed a wetlands permit for which no draft had been issued, a Clean Air Act major source permit for which no draft had been issued, an Army Corps of Engineers permit which had not been issued, and an interconnection permit, the hearing for which had not yet commenced. Is that correct?
That's correct.
Isn't it a fact, Mr. Niland, that these statements to the Federal Energy Regulatory Commission to the effect that this docket here is the only gating item for the plant, untrue?
No, I wouldn't say that. I think what this document here is dealing with was the CSO termination, and that the other permits that you just mentioned, the air and the wetlands permit, they have, they don't consider the CSO, whereas the EFSB proceeding does. So I think, I wasn't involved in the preparation of this, but if I have to speculate as to what the author meant by that, I think what he was referring to is that, the gating item, with respect to the EFSB, as it relates to the CSO.
Isn't it a fact, Mr. Niland, that you personally, yourself, have corresponded with the ISO's Simi Chowdhury concerning permitting of this plant?
Yes, I have provided responses to questions that she'd asked, yes.
Isn't it a fact that you have corresponded with Simi Chowdhury of the ISO about the wetlands permit and the air permit for this plant?
Yes.
Did you understand from your correspondence with the ISO that the wetlands permit and the air permit were important to the ISO?
Those were some of the key permits that were tracked in the forward capacity tracking system, yes.
And were those tracked by the ISO because they were important to the ISO?
They're important to the project.
And the Army Corps of Engineers permit is important to the ISO?
Yeah, I believe that was on the tracking system as well.
And the degree to which Invenergy does or does not have a permit to build an interconnection is important to the ISO, is that correct?
Yes.
And you personally corresponded with multiple, strike that, you personally corresponded with ISO staff about all those permits in connection with the forward capacity tracking system, is that right?
Yes, when the ISO would ask a question, relative to, whatever we were including in the tracking system, I was part of the team that would help put together the response. And in some instances would provide the response, correct?
And so information about Invenergy's air permit, wetlands permit, Army Corps of Engineers permit, and interconnection permit were all important to the ISO because without those permits, the plant could not be built. Is that correct?
That's correct.
And that's why they kept track of it as part of the forward capacity tracking system. Is that correct?
Yes.
Mr. Niland, you were asked a series of questions last week by OER's lawyer, Mr. Marcaccio, regarding the footprint power plant in Salem Harbor, Massachusetts, and the so-called footprint settlement, which is OER Exhibit 4. You recall that?
Yes.
I'm sorry, Mr. Elmer, I don't mean to interrupt. Are we done with this gating item thing now?
Yes. I'm sorry to disappoint you, Mr. Blazer.
No, actually, you met my expectations. Thank you.
Footprint is a gas combined cycle power plant, just as the Invenergy plant would be if that plant is permitted and built. Is that right?
It uses combined cycle technology, that's correct. I wouldn't say it's just like invented Clear River.
Are you aware of a number of salient differences between the footprint plant? Strike that. Are you aware of a number of salient differences between the footprint plant and this proposed plant?
Yeah, that's my understanding is it's a 2-on-1 combined cycle plant. You know, 2 gas turbines, 1 steam turbine, and the gas turbines were an earlier vintage GE. I think they're both air-cooled.
Are you aware of any other differences between the footprint facility and Invenergy's proposed facility?
The only other difference that I'm aware of is that footprint does not have dual fuel capability.
Anything else?
Nothing comes to mind.
Isn't it a fact that the footprint plant was built directly on the site of a former coal-fired power plant that retired after being sued by CLF?
I know it was built on a former power plant site, but
Let's leave aside the CLF lawsuit. Isn't it a fact that the footprint gas combined cycle power plant was built on the site of a previous power plant?
yes,
And are you aware of the fact that that previous power plant was a coal-fired power plant?
yes,
Isn't it a fact that if Invenergy's power plant were built, it would be built directly on the site? I'm sorry. Isn't it a fact that if Invenergy's power plant were built, it would not be built directly on the site of a previous power plant?
I think we can stipulate to that.
I'd like to have the witness answer.
You can answer.
yes,
Isn't it a fact that Invenergy's power plant, if built, would go directly in what is now a forest?
on private property, yes,
Isn't it a fact that the forest where Invenergy would be located, if it is built, was identified by the Nature Conservancy many years before this litigation was commenced as an especially valuable forest?
I'm not aware of that.
Were you here during Scott Cummings' testimony?
I was.
And you're not aware of the fact that the site of the Invenergy power plant was identified years before this litigation by the Nature Conservancy as a uniquely valuable piece of land?
I recall Mr. Cummings stating that the area where the plant is to be located, and I think he meant the forest in and around it, was somewhat unique, but your question previously just said that the Nature Conservancy had dedicated or
No, had identified.
had identified, yeah.
Had
I don't know if they identified specifically the Algonquin Spectra property itself, is what I was saying.
Were you in the room today when Mr. Osenkowski from DEM testified that years before this litigation was commenced, DEM had identified this property as being uniquely valuable?
He testified that the Rhode had attempted to acquire either a portion of the property from Algonquin, yes.
That wasn't my question. My question was whether you were in the room earlier today when Mr. Osenkowski testified that Rhode Island DEM had identified this property as uniquely valuable years before this litigation was commenced?
What I heard Mr. Osenkowski, if I said his name correctly, say was that the area where the Spectra property is located, which I presume he meant a larger area, that area they deemed as being valuable, and that they had attempted to acquire a portion of Spectra Algonquin property from Algonquin.
You were here earlier this month when Burrowville's witness, Mr. Zemba, testified that the site of this power plant is unusually rich in biodiversity and is home to several listed rare species, weren't you?
Yes, that was Mr. Zemba's opinion.
You're not aware, sitting here today, of any rare or endangered species that lived on the site of the Salem Harbor coal-fired power plant, are you?
No.
Objection, foundation.
Mr. Niland, would you agree?
Could I get a ruling on my objection, please?
Were you responding to his objection?
No.
What is it that you want?
I objected on the ground of foundation, but it looked like he moved on without getting an answer, so I'm going to assume the question was
No, I think
withdrawn.
we got an answer. Did we get we have an answer on the record.
We did?
I move faster than he does.
Mr. Niland, would you agree that building a power plant on the exact site of a previous power plant is quite different than clearing a forest to build a power plant?
It can be different. It'll have different challenges.
Can you identify what you're talking about when you say that?
The power plant site that you're referring to, we could use Footprint as an example. He said it was a coal-fired power plant. So, they may not have had a gas pipeline. So they had to build a gas pipeline, and my understanding was that they had to use an undersea gas pipeline in order to make that connection. There's one example.
Can you think today, as you sit here testifying, of any other salient differences between building a power plant on the site of a former closed coal-fired power plant and clearing a forest to build a power plant? Anything else at all?
Location to nearby residents may be an issue. As I said, gas, water supply, noise, all of those things.
Anything else?
Nothing comes right to the top of my head.
Okay. Isn't it a fact that the Footprint power plant is located in close geographical proximity to the important Boston load pocket?
It is my understanding.
And by load pocket, you understand me to mean a geographical area with heavy electricity load, is that right?
Yeah, I'm not that familiar with that particular area, but I know where Salem is, and it's nearby to Boston.
Isn't it a fact that the Invenergy plant, if it is built, would not be geographically proximate to the Boston load pocket?
It's in the SCNE zone, which now Boston is a part of.
And it's true, is it not, that the Invenergy plant, if built, would be located further away geographically from Boston than Footprint, is that right?
Yes, I would agree with that.
Isn't it a fact that because Footprint was built on the exact site of a recently closed power plant, Footprint was able to utilize existing infrastructure to connect to the ISO-run New England electricity grid?
I believe they use the same electrical interconnection that the former Salem plant had.
Isn't it a fact that isn't it a fact that the Invenergy plant, if permitted and built, would need to construct an entirely new interconnection line to connect to the grid.
Yes.
And in fact, that interconnection line is the subject of EFSB docket 2017-01, is that right?
That's correct.
And you were here last week when Mr. Zemba opined that there may be cumulative environmental impacts from construction of the power plant and construction of the interconnection line. Is that right?
I'm not sure what is meant by cumulative impacts that Mr. Zemba was speaking to.
Mr. Niland, is it your testimony under oath that you are not familiar with what cumulative environmental impacts are?
Mr. Zember was the biodiversity witness. So from his perspective, he was perhaps speaking about cumulative impacts as it may affect the biodiversity. Is that what you're referring to?
I would ask the stenographer to read back the pending question, please.
Mr. Niland, is it your testimony under oath that you are not familiar with what cumulative environmental impacts are?
I know what they are, yes.
Do you agree with Mr. Zemba that there could be cumulative environmental impacts from building both this power plant and the interconnection line?
Objection, foundation.
Hold on.
I agree that there could be impacts from clearing property for the power plant and for the transmission line.
Mr. Niland, would you agree with me that another difference between footprint and Invenergy is that the footprint plant utilized an existing interconnection to the grid, but Invenergy has an EFSB docket going because Invenergy would have to build a new interconnection?
I believe that's already been asked and answered a few questions ago, Chairperson.
You can answer that.
Yes.
You can answer.
You were here on January 23rd, 2019 when Burrillville's expert witness Glenn Walker testified about need?
Yes.
And you were here when he testified about a similarity and a difference between footprint and Invenergy?
I'm trying to recall specifically. I'm not.
I'll help. Ms. Verdi, let's look at the January 23rd, 2019 testimony of Glenn Walker, and let's start on page 39. Chairperson, I have a series of questions for Mr. Niland on specific aspects of Mr. Walker's testimony. Does he agree or disagree? And I'm going to have to read a medium-length section of that testimony into the record. I'll do it slowly for the stenographer. And then there's a specific set of questions pertaining to similarities and differences between Invenergy and footprint. Start at line 16. And as I say, I apologize about the length of this. There is a specific series of questions. Question at line 16, and that's what we're going to talk about now. I'm going to read the question on page 17, line 12, and the first word of your answer. The question is, do you believe that the ISO would have terminated Unit 1, the Unit 1 CSO, if its planning criteria indicated that the capacity was needed in the region? And the first word of your answer is no. Is that correct? We're continuing at the top of page 40. Yes. Question. Do you agree with Invenergy's witness, Ryan Hardy, that under the ISO tariff, section 3.13.3.4c, it's lowercase c for Charles, the decision of the ISO to involuntarily terminate Invenergy's CSO on Unit 1 was discretionary on the part of the ISO? Answer, I'll take your word for the tariff site, but the termination of the CSO is discretionary. Question, on the part of the ISO? Answer, correct. Question, so Mr. Hardy was correct that the ISO was allowed to terminate Invenergy's CSO, but the ISO was not obligated to do so. Answer, that is my understanding, yes. Question, in your expert opinion, would the ISO have exercised its discretion to terminate Invenergy's CSO if the ISO believed that Invenergy were needed now for system reliability? Answer, no, they would not have terminated. Question, why do you say that? Continuing on the top of page 41. Because we give an example in the December testimony about other cases where the ISO has worked extensively with a generator to bring a resource online in an area where it's needed for reliability. So if the ISO felt that this resource was needed for reliability, it is likely the best resource to provide that, and they found that that was not the case. Question, and what examples do you use to illustrate that important point? Answer, the example we use is the footprint plant in Salem, where they changed the tariff to allow for a 1-year waiver. And there's a series of testimonies from an ISO witness talking about how where resources are most needed, it will be difficult, if not impossible, to substitute that resource with an alternative, and that a resource midway through the permitting process is most likely the best resource to meet that obligation. So in that instance, they retained the resource. In this case, they terminated the resource's CSO. And when I, top of page 42, say this case, comma, in the case of CREC unit number 1, the CSO was terminated. Question, so you say they changed the tariff and they retained the resource, and the pronoun antecedent there is ISO New England. Answer, correct. Question on line 7 from Director Coit. Could I just dig into that a little more? There's been prior testimony that FERC approved the termination and made clear that their approval wasn't about need. They have a statement at the end of their opinion. So it's been offered that the length of the preliminary permitting process, the permitting program, comma, the permitting process, whoever is at fault there is the reason that the CSO was terminated, because it was just taking too long, it wasn't going to be ready. That's kind of a theory that's been put forward. So you're saying that despite that, can you just comment on that? Despite the length of the state permitting process, which doesn't necessarily jive with the pre-award of the CSO, that if the ISO thought the plant were needed, they would not have terminated. Top of page 43. Can you just kind of address that? The answer, starting at page 3 from the witness, yes. Page 43, line 3, the answer from the witness, yes. And I might parse that out a little bit if it's okay. I mean, we've seen in this general time period where Invenergy Unit Number 1 was awarded a CSO, several other plants that were also awarded CSOs, the Medway plant, the Canal plant, the Bridgeport Harbor plant, all of which have moved forward with construction. And so I'm not sure that you can say the permitting process and the FCA process don't coincide. But we'll set that aside for now and we'll look at the need issue. Obviously, the permitting process is delayed. But I think if the ISO thought that this unit was truly needed, that it would have retained the CSO and pushed this resource toward the finish line to bring it online. And when you have several factors going against it, one, the second unit has never obtained a CSO for this particular region. Two, it was able to replace the capacity with alternative capacity in the marketplace in a reconfiguration auction, which my understanding, Footprint, was it would have been difficult for Footprint to do in one of its obligation periods. My understanding is that in its second obligation period, it was able to do it, but there's clearly ISO testimony saying the waiver was the better way to move Footprint forward. And then finally, when they modeled this system with and without Invenergy, they really didn't find a difference with Unit 1 in, when I say they, when the ISO modeled this zone, with and without CREC Unit 1, they really didn't find a significant difference. So again, FERC did not rule on the issue of need. That's clearly in the case. It was at the end of the decision, but I also think that since ISO has the discretion to terminate and not the obligation, that if they felt this plant was truly needed, they could have extended that obligation and allowed Invenergy the additional year to finish the plant. Mr. Niland, is it fair to say, I'm going to ask you a series of questions, and in each case I'm going to ask you whether you understand that Mr. Walker was asserting something, and then I'm going to ask you whether or not you agree with him. Do you understand what I'm saying?
I think so, yes.
Okay. First, is it fair to say that in this section I just read, Mr. Walker was saying, in part, that a similarity between Footprint and Invenergy is that both plants obtained a CSO from the ISO, and both plants were behind schedule in being built in time to meet the obligation that came with the CSO.
It's fair to say that, yes.
And by CSO, you understand that we're talking about a capacity supply obligation, is that right?
Yes.
And Invenergy obtained a CSO for 485 megawatts in FCA 10, is that right?
Yes.
And FCA is an acronym for Forward Capacity Auction, is that right?
Yes.
That was conducted in February 2016 with the obligation to commence June 1st, 2019, is that right?
Yes.
Do you agree with Mr. Walker that a similarity between Footprint and Invenergy is that both plants obtained a CSO from the ISO and that both plants were behind schedule in being built in time to meet the obligation that came with the CSO?
There's a similarity that they both had a delayed schedule, so yes.
Is there also a similarity that they both had a CSO?
Yes.
And they were both behind schedule in being built in time to meet the CSO?
Yes,
So Mr. Walker, you agree with Mr. Walker on that particular point?
on that point, yes.
Is it fair to say that Mr. Walker was saying, in part, that a difference between footprint and Invenergy was how the ISO responded to the respective delays by footprint's owners and Invenergy's owners?
How the ISO responded?
Yes. My question is it fair to say that Mr. Walker's opinion, as he expressed in this part that I read, we'll come to your opinion in a moment. Just now, do you understand Mr. Walker saying in part that a difference between footprint and Invenergy was how the ISO responded to the respective delays by footprint's owners getting that plant built and Invenergy's owners getting that plant built?
So, yeah, Mr. Walker was saying that, he was, in my mind, he was alleging that the ISO responded differently in the case of footprint than it did for Invenergy.
Well, what do you think Mr. Walker was saying?
I think he was saying that for the footprint case, that he was stating that, you know, the ISO had some perception that required them to change the tariff in order to accommodate them.
Do you believe that Mr. Walker was expressing his opinion that the different responses that the ISO took to the delay by footprint versus the delay by Invenergy was probative or revealing of how much the ISO wanted or needed each respective plant?
I think he was expressing his opinion.
And did I paraphrase that opinion of Mr. Walker's fairly?
I think so.
Okay. Do you agree with Mr. Walker's opinion in that regard?
I have no way to know what the ISO was thinking in terms of how they viewed footprint.
So you have no basis to disagree with Mr. Walker's assertion?
Or to agree.
And you know that when footprint was not ready in time, the ISO changed its tariff and worked with footprint in order to ensure that the plant could be built.
I don't know the process under which the ISO took or how much they worked with footprint. I have no idea how they did that.
But you do recognize that when footprint was late, the ISO did have the discretion under the tariff to terminate footprint CSO.
I think so. Yeah, assuming the tariff language hasn't changed since then.
That's certainly the case now.
Yes.
And the ISO exercised that discretion in the case of Invenergy. Is that right? But that doesn't tell you anything at all about the ISO's view of the importance of Invenergy to the safety and reliability of the grid?
Objection. The witness has already said he doesn't know what was in ISO's mind.
He has testified that he didn't know what was in ISO's
Okay.
mind. Would you characterize your question as asking something different?
Yes. And I think it goes
And
to...
it is what?
I think it goes to the witness's credibility. I'm asking him whether he believes that the termination decision, the election by the ISO, which was not mandatory, but strictly discretional, reflects anything about ISO's view of whether this plant is needed. I realize that he may not know, and he can evade the question that way.
Objection.
Nevertheless, I believe his answer, whatever his answer may be, will be probative of the witness's credibility.
But it seems to me that you're, again, asking him about ISO's view, which he has already said he has no idea what ISO's view is.
I'll move on.
And I'd move that the use of the word evade be stricken from the record.
No.
Would you agree with me that an important difference between footprint and Invenergy's proposed power plant is the response of the ISO when both plants were delayed in being built?
I would agree that the ISO reacted differently, but again, I don't know that that has any bearing on, how they view one plant versus the other. I mean, from my perspective, the ISO was concerned about the scheduled completion times for the upgrades that Invenergy was obligated to do under its LGIA.
And by
Mr. Elmer, I'm sorry, could you please turn off your microphone when Mr. Niland's using the microphone because of the proximity of the...
Yes. Was your answer complete?
I think so.
And by LGIA, you mean Large Generator Interconnection Agreement?
Yes.
I wasn't asking, I'm sorry, could you read back his last answer?
Sorry, that was my fault.
I would agree that I would agree that the
ISO.
I would say ISO. I would agree that the ISO reacted differently, but again, I don't know that that has any bearing on how they do one plant versus another. I mean, from my perspective today, the ISO is concerned about the scheduled completion times for the upgrades that the energy is obligated to do under the LG.
Thank you. Mr. Niland, my question did not pertain to what the ISO's view of anything was, and I was not asking you to speculate about what the ISO view was. My question was, would you agree with me that an important difference between footprint and Invenergy's proposed power plant is the response of the ISO when both plants were delayed in being built?
I would agree that they responded differently.
But you wouldn't necessarily agree that that's an important difference between the two plants?
The two plants are different, What's the basis of that different from the ISO's perspective? I don't know.